Our law firm is often asked about the role of taxes and direct selling and network marketing, and usually there are two areas that seem to impact our industry. One is independent contractor status and withholding, and the other is sales and use tax collection by companies. Until 1982, there was a real issue as to whether or not our IRS and our government would recognize the independent contractor status of our direct sellers, or companies had to withhold from their income as if they were employees. At the request of the industry and after a long fight in 1982, Congress amended the Internal Revenue Code in an act entitled TEFRA, the Tax Equity Fairness Responsibility Act of 1982. And in that act, Congress specifically recognized independent contractor status of direct sellers, which saved huge bureaucratic costs to direct selling companies who could issue 1099s to their distributors rather than have to engage in an elaborate W-2 type withholding process. Very important for our industry, and the lead was followed in states across the country. The other area that has impacted our industry has been the issue of sales and use tax. All governments, state governments, of course, today are in dire need of more revenue and have sought to increase the taxing. Companies that market strictly on the internet, over the TV, across state lines, are shielded and are immunized from having to collect sales and use taxes because of the Commerce Clause of the U.S. Constitution, which prohibits states from placing a restriction on the flow of interstate commerce unless there is some type of a nexus or connection in the state. And it has long been agreed and a consensus in our industry that by having distributors in a state, by them recruiting, sending people to websites, driving traffic to websites, conducting training, recruitment, and promoting sales, that direct selling companies do have a nexus in the states. And therefore, almost all leading direct selling companies register to collect sales and use tax in states, and they do it on behalf of their distributors. Because if they don't do that, they have legal liability. But in addition, those companies that ask their distributors to be responsible for this are putting another obstacle to really getting out there and promoting, recruiting, and selling. And so virtually every direct selling company, including those that market on the internet, do collect and remit sales and use tax and do comply with sales and use tax laws at the state level.